I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are diving into a topic that's rapidly reshaping the digital experience for millions: kids, online safety, and the rise of age gating. It's a global issue affecting a population about which we all care deeply: our children. So, what's happening? Well, there's just so much going on, and it's hard to cover all of that in a single episode. So today we want to start with what's happening in the UK and US. In the United Kingdom, the recently enacted Online Safety Act is setting a new benchmark. Platforms hosting harmful content from pornography to self-harm material must now implement robust age verification systems, including biometric scans and government ID checks. Across the Atlantic in the United States, the landscape is becoming similar to what we've seen in privacy: a patchwork of state-level laws. Following a pivotal Supreme Court decision, almost half the states have different types of age verification requirements targeting not just adult content, but also algorithm-driven social media feeds. These laws vary widely. Some require photo ID uploads, others use AI to estimate age, and many raise serious concerns about privacy, feasibility, and free speech. Inherently, there is a tension at play. Namely, is there any measures that platforms, websites can put into place that are truly going to protect kids online? Or frankly, are we just shifting around the burden to users and platforms? And in trying to solve this issue around age gating, are we creating other legal challenges and concerns? So I'm really excited to start the conversation here today so we can cover the UK's aggressive regulatory approach, the United States' fragmented but fast-moving approach, and frankly, the broader implications for what this debate means for privacy, platform design, and the future of kids' online safety. Let's get into it. So, to discuss, I've invited a few of my colleagues to the podcast: Fett and Georgia Crawford, our London office, and Sophie Bohm from our Colorado office. We have both the UK and US covered. All of Rob, Georgia, and Sophie spend a lot of time working with clients on these issues, and I'm really excited to get their perspectives. Rob, Georgia, Sophie, welcome to the podcast.
Thanks for
Thanks for
having us,
having
Scott.
us. Thank you.
So, Georgia, maybe I can ask you to get us started, because I think the phrase online safety is being used, all the time now, especially in a lot of the laws that are popping up. But some of those laws are designed to address different types of issues, different types of harms, different types of considerations, frankly, just different types of policy. So, from your perspective, maybe starting in the UK, where has been the online safety debate to date? And where are you starting to see these laws start to come into effect to address those issues?
So the way in which online safety has been thought in the UK has changed over time. So historically, there were minimal obligations on platforms themselves. So the services that you use on the internet, social media sites, marketplaces, to protect users. And the way in which we thought about, for example, protecting children online was to provide parental roles and put obligations on parents to protect their children. Increasingly, however, obligations are being put on the platforms themselves to protect users. So broadly, online safety is about, in this context, is about platforms being aware and assessing the risks and threats that are on their services, then taking steps to protect users from them. And when we talk about harms, the kind of conversation about online safety in the UK has really ramped up recently, particularly in the context of protecting children from online harms. And this has kind of led to a split in the way that content online is regulated. So on the one hand, we're regulating content that is illegal or content that facilitates the commission of offences offline. So that's criminal offences. But then there's this kind of second category of content that we're now talking about a bit more, which is content that is legal, but that is harmful to children. So this includes content such as content that encourages suicide or eating disorders, but it also includes violent content, abuse, and hate. So there's a real kind of range of types of content and types of harms that we're talking about these days when we're thinking about online safety.
So, I mean, is that, Georgia, as you're thinking about that, the harms or the kind of the areas where they're looking at, is it specifically around content? What types of content would be permissible to what types of audience? And in particular, what type of content would be able to be accessible to children or individuals who are under an established age? Is that the right way of thinking about this at a general level in the UK?
Yeah, so in respect of content that's harmful to children, that's exactly right. So the things that we're concerned about are the content that users can encounter, and it's specifically for types of services that the Online Safety Act defines as user-to-user services. It's content that a user uploads, shares, or generates that can be encountered by another user. So it doesn't include content that the provider of the service puts on the service themselves, but it is that content that a user uploads and another user can see. So that's in respect of both content harmful to children and illegal content. There's another kind of category, which is in respect of illegal harm, so the criminal offences. There are also obligations around preventing content online facilitating the commission of offences offline. So that's a slightly, we've kind of jumped a bit there from just things that you see on the platforms that you're using to then having to make a judgment call about whether something that you're seeing online, while the content itself might not be illegal, whether it would facilitate the commission of an offence offline.
Makes sense. So then maybe Sophie, from your perspective in the United States, online safety also has a number of different connotations and different types of meanings. Age restrictions is one of those. How else are you seeing the types of harms and the types of concerns being raised where online safety is necessitating new policymaking?
Sure. So I think we've seen a really similar trend in the US to what Georgia was just describing in terms of the increased focus on online safety issues and children's safety issues. We're seeing, and I know we'll talk about this in a couple of moments, but a real increase in the number and scope of state laws and increase in efforts at the federal level as well. And these types of online safety laws, there are a couple of different types of them. Some of them try to regulate platforms that provide primarily adult or mature content, but a number of them also try to regulate platforms that are maybe social media sites, gaming sites, kind of a broad definition of platforms that have interactive features. And so a lot of these laws, they all have sort of a different grab bag or mix of elements, but we see them having elements that include age verification, for example, which I know you mentioned, certain parental controls that are required. You might have certain controls for users, data privacy obligations, transparency obligations, risk assessment requirements. And so there's a lot of different elements that come into play that we're seeing across the US. You also mentioned, Scott, age verification or age assurance. And I want to talk a little bit about that because there are a couple of different types. When we talk about age assurance and age assurance requirements in the US, there are a couple of different flavors of this. And so age assurance is sort of the umbrella term that encompasses all these different things, but some of the laws that we're seeing require companies to predict age or to assume age. And it's okay under those laws for some companies to rely on self-declaration. So similar to COPPA, the Children's Online Privacy Protection Act, it's okay for users to self-report their age. But what we're seeing, though, is a trend towards age estimation or age verification. So under age estimation, it's reasonable in that context for a company to rely on inferences that they glean about their users or about their behaviors of their users to estimate what their age is. And then under age verification, you see kind of stricter standards. So that might be relying on a payment card or government issued ID, digital ID, facial recognition, these kind of hard verification steps. And so we're seeing a trend more in that direction for certain types of laws. And we're also seeing a mix of some laws which require explicit age verification requirements, or they have them in the laws, and some are implicit. So they might not say, you must verify age or you must estimate age, but then they're saying when your users are under X age, you must do this, which is, implies that companies would have some idea of that. So kind of all to say, it's still a really mixed bag at the moment and moving very quickly in a field that's developing rapidly.
Yeah, I think really good point, Sophie. And I would want to get into, what does the law require? What are these new laws that are going to require with respect to assurance or verification or kind of all of the various different types of tools that may be available. But before we maybe get into the solutions, let's kind of make sure we have a good idea of, where these laws are popping up and specifically what do they require. So if I think the way that I am looking at this, and certainly anyone on our virtual panel here disagree, is that we have very specific laws that are coming into place that are designed to target online safety. And then we have, call it the legacy laws, the laws that are generally applicable that apply to all different types of activities, whether that is the GDPR or COPPA, that will also have a role here in connection with online safety related policy debates. So maybe, Georgia, I'm going to ask you to talk a little bit about what I think is a relatively new law in the UK Online Safety Act. And then maybe Rob would love to have you to join the conversation and talk a little bit about how the GDPR may be thinking about issues surrounding online safety. So Georgia, to you first.
Yeah. So the Online Safety Act introduces a new regulatory regime for online platforms that gives those platforms legal duties to ensure user safety. So it came into force at the end of 2023, but the obligations are being introduced in stages. And the first obligations in respect of the safety duties came into force earlier this year. At a high level, OSA requires in-scope services to carry out risk assessments of their platform, and then in part based on the results of that risk assessment, to take steps to protect all users from illegal harms. So that's the content that constitutes a criminal offence that we were talking about, or the facilitation of offences offline, and then to protect children from content that's legal but harmful to children. So various different types of platforms are in scope of the Act. So similar to kind of what Sophie was talking about, there are different categories. So there are pornography services, user-to-user services. So this is where a user can upload content that can be encountered by other users. So this includes social media services, marketplaces, gaming services, things like this. And then finally, services. So a service with a search engine that searches multiple databases. And Ofcom is the regulator of online safety, and it issues codes of practice and guidance for providers that contain measures that those providers need to comply with to show that they've complied with the duties in the Act. There are specific obligations in respect of age assurance. So the obligations require platforms to use what the Act refers to as highly effective age assurance in circumstances. So for sites that publish, so pornography sites and sites where the primary purpose is the hosting or dissemination of content that's harmful to children, providers are required to use highly effective age assurance to prevent users from accessing the service unless they've been determined to be an adult. So that acts as an age gate. So content on the service is not visible to users before they've gone through this highly effective age assurance process. And then on the other hand, the other user services are required to either prohibit content that's harmful to children in their terms of service and enforce this prohibition, or use highly effective age assurance to prevent child users from encountering this type of content. So identify which users on your platform are children and then prevent them from seeing the content that is harmful to children. There are some exemptions. So if it's technically infeasible to implement those controls, then you don't have to do it. And there are kind of various different applications depending on the risk level of the service. But those at a high level are the age verification requirements. And Ofcom's provided extensive guidance about what constitutes highly effective age assurance. So any age checking methods used by services have to be technically accurate, robust, reliable, and fair to be highly effective. And there's a non-exhaustive list of methods that are considered to be highly effective. So these include facial age estimation, photo ID matching, credit card matching, things like this. But self-declaration and the use of payment methods such as debit cards that don't require you to be 18 are explicitly noted by Ofcom as being not highly effective.
So, Georgia, I mean, it's kind of fascinating in the way that this is developing. And maybe one follow-up question here before we could talk about the GDPR implications is that, you mentioned that this is, really designed to address that content that's harmful to children. And while oftentimes there is a broad consensus around, thinking about that at a very high level, with any type of content-based restriction, there is lots of disagreement about what falls into what category, right? I mean, in other words, there are probably, if you look at pornography and you'd say like, well, you know it when you see it. Well, some people look at it and they say, okay, well, something that appears on a website that's named porn, clearly pornography, but something where I look at a social media website of people who are models and walking around in their underwear, is that pornography, right? Like, and there's probably different views on that. And so interested in how those big kind of threshold definitions have been sorted out, and how people are coming to a position of whether an eating disorder is just anorexia, or whether eating disorder means that you're eating fast food every day, right? And I imagine there's probably different points of view on that. How are those big questions being solved?
Well, this is a problem that service providers have been talking about since the Act was a bill. And this is part of the problem where we're moving from identifying content that is an offence. So the definition of the type of content is set out in law, to this kind of type of content that is legal but harmful. And as you say, particular types of content are harder to identify than others. So and will also affect whether you think that the content falls within that definition might depend on your personal experiences. So for one person, content might constitute something that encourages an eating disorder, whereas for someone else, it could be content that helps them if they're in recovery. Ofcom have published quite a quite a large guide that sets out what they consider to be content that falls within each of these types of categories. But this is definitely something that service providers are grappling with. And it becomes even harder when you introduce kind of automated content moderation requirements, because it's not just a human looking at a piece of content and making a judgment about whether it's eating disorder content, where they might have, the context, they might see the content that's around it. Because of the amount of content that's on these platforms and the scale at which this content moderation is happening at, a lot of these processes need to be automated, which kind of adds a further problematic element to this.
Yeah, a really interesting. So, Rob, interested in your perspective on this, these set of policy debates, and in particular, how is the UK GDPR applicable here, if at all?
Yes. So George has talked a lot about this concept of kind of age assurance, and also the way in which UK law is sort of structured to provide for these sort of codes of conduct. Now, when we look at the GDPR has always had in it some elements around protecting children. So, for example, we've had different countries having different ages at which parents can give consent on the child's behalf, and also the sort of test within legitimate interests, where there is sort of some additional protection for children. But in this context of kind of online safety, one of the most important parts from the UK perspective under UK GDPR has been the age-appropriate design code, which is sometimes called the Children's Code. And that sets out a number of ways in which online services are expected to kind of provide additional protection for children online in relation to their personal data. And this code applies when for services where a child is likely to access that service. And one of the particular areas that it talks around is actually around the sort of concept of age assurance. And I think George has mentioned some of the ways in which age assurance can occur. Now, the Children's Code doesn't specify exactly which of these methods of age assurance should or should not be used. Is kind of left to the discretion of the service, depending on its sort of particular context in which that service runs and the particular risks of that service. But more recently, the ICO has published an additional opinion, which is very much tied into and sort of been worked on in collaboration with Ofcom in relation to the Online Services Act. And so this opinion on age assurance kind of talks about which of these methods might be more appropriate, or what you should do if you can't find a way to protect, your service, from children accessing that service. And it actually does say that, ultimately, if it's not appropriate for a child to access your service, then you should focus on restricting that access. But more broadly, from a data protection perspective, the Children's Code also talks about access to services, being appropriate perhaps for different ages of children. So, for example, some services might be appropriate for an 8-year-old, a 10-year-old, a 13-year-old, whereas other services might be restricted to adults. And so it really kind of makes that distinction between different ages. And so this actually creates some interesting problems, because whilst obviously adults may have access to some form of formal identification for them to kind of prove their age in the context of, for example, pornography. On the sort of level of trying to tailor your service to different ages of children, that could be more difficult, because a 10-year-old or 13-year-old might just not have that kind of proof of identity and proof of age. So the Children's Code talks about how you might be able to use, for example, age estimation services, for example, looking at, what somebody's face looks like and how you can estimate the age of that face. And that has some data protection considerations as well, because obviously data should be accurate. So how accurate can that be? That could also have implications, for example, for demographics, different races of persons, where, is that, has that age estimation feature been trained on the right data? Is it biased towards certain demographics? So there's a lot of data protection issues which come up when we start talking about age assurance.
So, Rob, I guess one key threshold question, because, you have taught me a lot over the years, including that the GDPR, one of a core tenant principle is data minimization. You should be trying to limit the amount of data that you're collecting. And yet now I'm hearing, as we start to see this picture start to be painted in front of us, we're like, well, yes, as a general principle, we should minimize the amount of information. But at the same time, now we want to greatly expand the amount of information that we're collecting, including really sensitive information, biometric information, information that would be needed for purposes of running through AI tools to be able to make an automated decision as to whether somebody is of an appropriate age to be able to access very specific content, to be able to flash in front of a screen, which will be captured forever, your driver's license, your passport, any number of different things where now we're saying, well, yeah, we were serious about this data minimization principle, but now in this context, that's a giant exception. How is that being sorted?
Yeah, very good point to make. And I think the sort of headline response to that is that the UK GDPR always takes a risk-based approach. And so there's never any kind of one solution to any one problem. You should always be trying to balance all the different considerations and all the different requirements of data protection. And I think the ICO, which is the UK's data protection regulator, has always been, quite clear that when it comes to children's data, that is sort of there's an overriding objective there to make sure that services are appropriate for children, and that ultimately the best interests of the child are protected, and the number one aim of the Children's Code. So when it comes to things like collecting data and storing that data and using that for training, I think the ICO would tend towards collecting that data if it is ultimately to protect a child. That's the ultimate objective. However, we can also look at what other methodologies there are to achieve both at the same time. So, for example, if we're trying to protect an internet user's activity online and to ensure that, what happens if there's a data breach and the websites that people are using sort of ends up being leaked. Well, could there be ways to protect that information in a way which achieves both of those objectives? So I think some of the guidance, not in the UK, but elsewhere around Europe, talks about having like a double-blind system so that the interface between the user and the sort of age assurance is with a particular company that's fairly content neutral, but ultimately that connects in with whichever website or service is trying to understand the age of its users.
Yeah, I mean, really interesting. It sounds like, all right, well, the GDPR is, establishes this flexible framework, but we need to have additional flexibility perhaps for kids. And, maybe some of the other core principles that, embody the GDPR need to, allow for that flexibility to be leveraged when we're talking about that vulnerable population. And, maybe Sophie, I know you know a thing or two about this too, because, that issue surrounding, well, what additional issues are we going to do with kids' data in the United States has long been the source of distinctions that are being made, heightened levels of obligations that organizations and companies have with respect to protecting kids' data that doesn't apply to adults' data. And that's been an area where policymakers and politicians have largely agreed that kids in particular need to have these heightened degree of privacy rights, heightened degree of privacy protections. How are you seeing both the new laws pop up that are specific to online safety, and then importantly, how are you seeing those legacy or those existing laws be applicable to the same policy aims?
Yeah, thanks so much for that question, Scott. I think just to take a step back, for many, many years in the United States, there was this core law, COPPA, which essentially regulated the collection, use, and disclosure of personal data or personal information for children under 13, kind of conceived as a children's privacy law. And that was really almost all we had in this space. But in the past couple of years, you've seen some efforts at the federal level to try to have some online safety laws as well. So you saw something called the Kids Online Safety Act, a couple of versions of this bill trying to get passed by the legislature. But kind of all to say, there's been efforts, but we still don't have a single comprehensive federal safety law or safety law for kids. But online safety bills and laws are growing in popularity at the state level. And a number of approaches have popped up and evolved in recent years. So you have a number of states, California, Maryland, Nebraska, and Vermont among them, although some pieces of those laws have been enjoined, that are looking at age-appropriate design code laws, which are modeled on the code that Rob was just discussing. You have another set of types of laws at the state level, which are focused on age verification and parental consent. Those tend to have a more narrow focus on restricting access to platforms with certain types of content. And then you also have, as another category, laws that more directly regulate the use of, I mentioned this before, social media or online services, and seeking to curb addictive use of those types of services. And all of these laws have different elements that they sort of pick and choose. And so, for example, you might have usage restrictions or parental controls as one category of things that they try to regulate. And within that, you see, engagement restrictions. So requirements to set mandatory breaks for users or duration triggered check-ins, the ability for parents to set screen time restrictions, for example. The laws might try to regulate communication. So the ability to revise direct messaging settings that are default in the platform, or view a list of the connections that you have, or block accounts. You have content sensitivity settings. They might try to regulate parental notifications or require parental notifications when, for example, a younger user changes default settings or parental settings that have been already set on a platform. They might try to regulate financial transactions, so restrict the ability of people under a certain age to enter into financial transactions or to require them to get consent to do so. Now, these laws also have a number of different categories that they try to regulate. So they might try to regulate design features. I mentioned addictive feeds or features, and I almost want to put addictive in quotes because that's the language that's used in the statute. But they might try to restrict messaging between unaffiliated accounts, for example, or between users that fall within different age groups. They might impose default settings for visibility of youth accounts. So for younger users, they might not be able to be searched by others, for example, or they might require the disabling of indexing for search engines. And then you have, and Georgia touched on this with the OSA, risk mitigation requirements in a number of these laws. So we've seen data protection impact assessments or risk assessments being required by comprehensive state laws, but we're also seeing those now popping up in online safety legislation. And so these requirements say that companies have to do a risk assessment for potential harms, including content that is potentially harmful to children, before offering a product or service with certain content. Now, that is kind of an interesting piece because there's been a lot of pushback on that, especially in the First Amendment context. And there have been some successful challenges in court. But we're seeing laws sort of change and adapt to those court decisions and still continue to try to impose some type of risk assessment requirement.
Yeah, I mean, Sophie, on that point, the risk assessment requirement, in particular, whether that is essentially being forced speech is, one of the ways that I think the courts have looked at that. But even taking out of risk assessments, in the United States, obviously one of our core policies is the freedom of expression and free speech, which the courts in the past couple of Supreme Courts have been very protective of and struck down a number of statutes across a variety of different domains on First Amendment grounds. What we're talking about, I think, is that a lot of these laws are really going after specific content. And any law that targets content or a specific viewpoint is going to get that strict scrutiny that the court applies, which maybe laws that are specific to children will survive strict scrutiny, but just interested in how you mentioned a number of these have been essentially enjoined. Where do you see that development going as legislatures are trying to address really important issues for kids online, while at the same time being true to that First Amendment principle?
Yeah, that's a great question, Scott. And we've actually gotten a little bit of an answer on this, although, of course, still developing in its early days. But about just a couple of months ago in June, the Supreme Court issued a decision in a case called Free Speech Coalition versus Paxton, and it upheld a Texas law that required consumers to verify their age before accessing online or adult content or sexual content sites. And so, interestingly, about this case is that typically, as you mentioned, strict scrutiny would be applied for content-based decisions in this context, but the court departed from that precedent and it applied intermediate scrutiny to uphold the law, with the finding that it advanced important governmental interests unrelated to the suppression of free speech and didn't burden it substantially more speech than was necessary. So this departed from the precedent that we saw in cases like Reno and Ashcroft, which I think you were thinking of with that strict scrutiny standard. But it's really interesting to see whether this will only apply, for example, in the context of content that the court seems to think is harmful to children, which is that adult or sexual content, whether this departure from the strict scrutiny standard would apply in other contexts, or if they would go back to intermediate scrutiny. So I'm thinking, for example, of if you had how they would apply this to states that had design elements in their laws, like age-appropriate design codes or laws that target algorithmic feeds or algorithmic ordering of content. Those might be more likely to survive if they're deemed to be incidentally burdensome to speech. So it's a really interesting time to be looking at these issues. And I think we're going to see a lot more evolution, especially as state courts and lower district federal courts start to engage with these issues.
Yeah. And, I think in some ways, Sophie, what you're describing is a little bit easier to design some of these standards and practices for perhaps new offerings, but to try to apply these requirements to essentially existing products and services presents a real challenge for organizations who have products and businesses that are designed perhaps with not anticipating doing this. So maybe as we kind of are, bring the episode to a close, I'll maybe ask each of you for your perspective on, how are you seeing organizations manage compliance issues under this, and where do you see those practical challenges arising? And from your perspective, any practice points for practitioners in the space who may be asked to oversee their organization's efforts to comply with these issues and are just now trying to get their arms around how to start. Georgia, why don't you go first?
So in respect of the kind of OSA more generally, there are governance requirements that services are expected to comply with. So there are kind of structures that are set out for platforms to follow that they can start with. So there are individuals named that are responsible for online safety, but there are, layers of different obligations that come into force at different times from the Online Safety Act. And there's obviously a kind of risk of fragmentation in compliance across different jurisdictions. So it's quite important to take a holistic approach to the compliance obligations that are coming into force and seeing where there are cross-cutting duties and where you can kind of mobilize compliance in one area to help you comply in another. In respect of age assurance specifically, it's important to think quite carefully about whether there is a need for your service to implement age verification. So there are quite specific requirements in respect of which services need to apply, which in part depend on the result of the risk assessment that you will have carried out, and in part on the functionalities and features of your service. So if it is the case that your service needs to comply with requirement to implement highly effective age assurance, you should then ensure that that system complies with Ofcom's quite prescriptive guidance on what makes a system highly effective. And then there are other associated requirements in Ofcom's code of practice that you'll need to comply with. So, for example, if you carry out age verification, you also need to provide users with the ability to appeal an age assessment if you think that the service has assessed the age incorrect.
Yeah, so we're talking about someone tries to visit a pornography website, gets denied because they are determined to be underage, and now we have to go through, the appeals process to see whether that person is able to be allowed into the website.
Yeah, exactly. There are kind of follow-on obligations that flow down from the initial obligation as well.
Has the ability of changing the way that I think users expect to use the web. Rob, interested in your perspective as you're counseling clients in this area, any practical challenges that you see, especially under the GDPR, and ways that new responsible individuals for these can be able to manage those obligations.
Yeah. So I think probably one of the very first things to think about is actually how likely is it that a child would be using your service or your website. And, if we think back, sort of just a few years ago, it was very common to put into, terms of service, particular age, and maybe 13, for example, in the UK, at which somebody would not be able to use a service, and to kind of rely on that contractual requirement. But the ICO has said very clearly, and it has issued fines on this point, that you can't just bury your head in the sand and assume that children are not accessing your service just because you put this kind of contractual limitation in place. Instead, you really need to dig deep into whether children are accessing the service, what age that might be, because if you don't, the ICO will actually attempt to do it. And as I said, there has been a fine on that, which is being appealed. So I think that's one of the very first steps. And then once you've done that, then of course it's following those usual GDPR processes and compliance steps. So particularly in relation to documenting your analysis, conducting data protection impact assessments, just so that if you are ever questioned by a regulator as to what your approach has been and why you've protected rights in certain ways or which age assurance methods you've used, having that documentation to justify that, the ICO is likely to have quite high regards to that analysis. Whereas if you hadn't done that analysis yourself, the ICO may well do it for you or may criticize you having thought about the problem.
I think it's really good. I think that demonstration around kind of the responsible uses of technology, and in particular, how is it that you're trying to kind of get out ahead and show, while maybe perfect compliance in this area is really elusive, how is it that you're taking responsible action to try to address these concerns goes a long way. Sophie, maybe I'll give you the final word. How are you helping your clients think through how to sort through the morass of US laws that may apply in this particular space?
Yeah, I think it's a lot of the similar advice that Rob and Georgia are giving their clients in terms of doing an upfront assessment and risk assessment of whether these laws may apply to you. I think in particular in the US, it's important to remember some of these laws apply to the entity and some of them apply to a particular service. And so you might want to think about, is the content that might be regulated, is that your core product or service, or is it just one element of your business when you're assessing whether these laws might apply to you? Obviously, you will want to take a look at the kids and whether they might be on your platform. So do you have actual or constructive knowledge of kids on your platform? Or when I say kids, I don't just mean under 13 anymore, right? I mean under 18, under 16, depending on the law. What is the age range that you're targeting? What is your intended audience? Is there mature content on your service? Do you offer social features like the ability to connect to others? And then once you kind of have an idea of whether you might be scoped into these laws, it's important to take a look and work with your engineering teams, your product teams to build in some of the requirements. So if, there are laws that say, for example, if you collect precise geolocation information from a younger user, you have to display a signal to them to let them know. So you want to make sure that when you're developing this service, that you have the ability to display such a signal, or that you have the ability to allow a parent to come in and make a different choice about the privacy settings, for example, or the default settings of your platform. And so you don't want to get to a place where it's perfect, you tie it up with a bow, you release it into the world, and then all of a sudden you realize you have all of these online safety obligations. So I would say it's really important to do that initial assessment up front of whether you might be scoped in, and then if you are, what are the obligations that you might have.
Fantastic. Well, and as I mentioned in the area, I'm sorry, at the beginning of the episode, that this is an area that is going to likely see a lot of additional legislation and policy making. You have representatives here in the UK and the United States. These are not just issues that relate only to the UK and the United States. They're truly global. It's not like there are two countries in the world who only care about kids. Everybody cares about kids and trying to figure out how they can responsibly use technology. And thus, I think we can all expect that this will constantly be a source of policymaking and attempts to draw the balance between free speech and safety and content based restrictions and age verifications that will probably be, the course of the next career for everybody who's listening to this and figuring out where they would want to study, where they want to practice law, where is it that they want to focus, a key and important area to follow. With that, Georgia, Rob, Sophie, thanks so much for joining the podcast today.
Thanks, Scott.
With that, my name is Scott Loughlin. This is the Data Chronicles, and those were your data points.